Welcome back to the deep dive. We're continuing our journey through the MPP, the Manual of Patent Examining Procedure, breaking it down piece by piece. Today, we're diving into Chapter 400, Representative of Applicant or Owner, specifically MPP Section 406. That's the one about the death of patent practitioner.
That's right. And our goal here is really for you, the listener, to get a solid handle on what happens procedurally, legally, when a registered patent attorney or agent passes away. It sounds maybe a bit morbid, but it's crucial for protecting your application if you're an applicant or owner. It's about understanding the USPTO's safety net.
Absolutely. It deals with a really fundamental aspect, the power of attorney, the POA, under, well, the most difficult circumstances. So let's unpack MPP 406, starting with the absolute core principle. What happens to that power of attorney, the authority granted to the practitioner at the moment of their death?
It's immediate and absolute. The power of attorney is automatically revoked, instantly.
Instantly. Wow.
Yeah, the moment they pass away, that authority granted by the applicant or owner just ceases. There's no grace period, nothing.
And no transfer. Right. That's the part I find really striking.
Exactly. That authority cannot be transferred or continued. It doesn't pass to an associate, a partner, or the firm itself.
So wait, even if the practitioner worked at a large firm and they had, backup attorneys designated internally, the firm can't just keep things rolling?
No. The USPTO views that power of attorney as strictly personal. It's tied to the specific registration number of the individual practitioner you appointed.
Ah, okay. So the authority flows from the client to that specific person, not to the entity they work for.
Precisely. So even if it's Global Patents Incorporated, the POA linked to the deceased individual is gone. Kaput.
So the firm can't just sort of substitute someone else in automatically.
I know. For the work to continue with representation, the applicant or the owner must formally appoint a new registered attorney or agent. That means filing a new power of attorney document.
That really emphasizes how seriously the USPTO takes authorized representation. It's not like passing on a file folder.
Definitely not. And think about this. Even if the deceased practitioner left clear instructions, like have my colleague Jane Doe take over my cases, the office won't recognize that.
Why not, if it was the practitioner's wish?
Because the underlying authority, the POA itself, has been extinguished by death. You can't transfer something that no longer legally exists. The office needs clear current authorization directly from the client.
Okay, so accountability is key. The USPTO needs to know, without a doubt, who is authorized right now.
That's the bottom line.
Let's consider a scenario then. Say the practitioner dies the day before a critical office action response deadline. The POA is instantly revoked. Does the client get any kind of automatic extension because of this awful event?
That's a tough but important question. And the answer is, unfortunately, no. There's no automatic extension granted because of the death.
Really? Even under those circumstances?
Yes. Because once the POA is terminated, the applicant or owner is considered pro se, or unrepresented, for procedural purposes. The responsibility snaps back to them. The deadlines are fixed to the application, not the representative, so that deadline still stands. The client would need to file the response themselves or quickly appoint new counsel who can file it, or file for an extension of time if one is available.
Wow, that underscores the urgency. The client needs to know immediately that their representation status has changed. Which brings us to communication. Once the USPTO is officially notified, presumably by the estate or the firm that the sole practitioner of record has died, what does the office actually do regarding pending applications?
Right. So the USPTO kicks in what we can call a dual communication strategy. It's a two-part approach to make sure the client is informed while maintaining the official record.
Okay, what's the first part?
Well, first, they actually continue to send correspondence related to the application to the deceased practitioner's last known office address.
Why do that if the attorney is deceased?
It's really for procedural integrity. It ensures the official file record shows that the office sent the communication according to the information it had on file at the time. It documents the attempt.
Okay, that makes sense for the record keeping. What's the second, and I imagine more critical part?
The second part is crucial. Simultaneously, the office sends a copy of that same communication directly to the party who originally appointed the practitioner.
So directly to the inventor or the company that owns the patent application.
Exactly. The applicant, the assignee, whoever the client of record is, this is the USPTO, essentially bypassing the now defunct POA and contacting the principal party directly. It's like an alert.
So this dual mailing ensures the actual owner gets the message, even if, say, the deceased attorney's office is closed or mail isn't being checked promptly.
Precisely. It's a safety measure.
What does that communication say? What's in that notice that the client receives?
It's very specific. It clearly states, 1, that the power of attorney previously granted has been terminated because of the practitioner's death.
Okay, straight to the point.
Yes. And 2, importantly, it informs the client that they may appoint a new registered attorney or agent to handle the application or patent going forward. It basically says you need new representation if you want it.
So it's not just informational, it's a prompt for action. Let's use that example of the solo inventor whose attorney passes away unexpectedly. How does this process protect them?
Okay, so the inventor appointed Attorney Smith. Attorney Smith passes away. The application is pending, maybe an office action just issued with a 3-month deadline.
Right, and the inventor might not know Attorney Smith has passed or might not understand the POA implications immediately.
Exactly. If the USPTO only sent that office action to Smith's office, the inventor might never see it. The deadline could pass, and the application could go abandoned. Big problem.
But with MPP 406...
With 406, the office sends that office action package to Smith's old office and a copy directly to the inventor's address. That copy includes the critical notice we just talked about.
So the inventor gets the rejection details and the explanation. Your attorney's authority is terminated. You are now responsible. Appoint new counsel if needed.
Correct. It puts the ball squarely back in the inventor's court, giving them the information needed to act, either respond themselves or, more likely, find and appoint a new patent practitioner quickly. It prevents abandonment due to lack of notice.
It's a system designed to uphold the strict rules of representation while also protecting the applicant's rights during a difficult transition.
That's a good way to put it. It maintains procedural integrity while ensuring the client isn't left completely unaware.
Okay, so the big takeaway here really reinforces the idea. Representation before the USPTO is deeply personal. Death means instant revocation, no transfers allowed, and the client must take action to reestablish representation.
It truly highlights that fiduciary duty rests with the individual practitioner you authorize.
Before we finish, we definitely want to give a shout out to Mike Shepard. He's the creative director who envisioned and organized this whole MPP audio series. His work has been key to making this complex material more accessible.
Absolutely. And as always, we need to include our standard disclaimer. This summary, like others in this series, was developed with the assistance of AI tools. It might contain errors or omissions. It's intended for general educational and informational purposes only. It is definitely not legal advice, and it's not a substitute for formal instruction.
That's critical. For authoritative guidance, you always need to consult the official MPP itself. Talk to a qualified instructor or engage a registered patent practitioner for your specific situation.
Please keep that in mind.
Okay, so we'll leave you with a final thought to consider, stemming from today's discussion on MPP 406. We've seen the procedures the USPTO follows when notified of a practitioner's death, this dual communication, the focus on revoking POA. It highlights how carefully they manage the end of representation. So think about the flip side. If managing representation upon death requires this much administrative effort to maintain integrity, what does that imply about the ongoing burden for the USPTO?
You mean tracking active practitioners?
Yeah, exactly. Consider the continuous effort needed to track and verify the status of all registered practitioners, not just deaths, but also things like suspensions, disbarments, name changes, address changes, retirements, voluntary resignation.
Right, because every active power of attorney relies on that practitioner being in good standing and currently registered.
Precisely. How extensive must the administrative machinery be just to constantly validate that massive roster of representatives and ensure the integrity of who's allowed to act before the office today? Something to think about. Thanks for joining us for the deep dive.